We have Team 19, Kaya Anderson, Renee Taillieu. Congratulations. And we also have joining them Team 11, Emma Aggett and Tony Pascale. Congrats. And we're going to start at 4:30. So get ready. Thank you so much. I appreciate it.
Walker Health Law moot would like to acknowledge that today's moot is taking place on the unceded and unsurrendered territory of the Algonquin people, traditionally known as Anishinaabe. Algonquin people are the original inhabitants of the wide swath of territory along the Ottawa River. In Algonquin culture, it is appropriate for guests to acknowledge the hospitality of their hosts when entering their territory. With this tradition in mind, the Walker Health Law moot respectfully thanks the Algonquin people for hosting us on their ancestral lands, miigwech. Before we begin, I would like to remind our spectators that their microphones should remain off at all times. For judges and participants, please keep your cameras on and microphones should be on mute when not speaking. All present in the Walker Moot Supreme Moot Court. The final round of the Walker Moot Supreme Court is now in session. It is with great honor and privilege that I present Justice Anthony Desmis, the Director of the Canada Branch and Education Chair of the Chartered Institute of Arbitrators, Justice Adam Dodek, Dean of the English Common Law Faculty of the University of Ottawa, Justice Jim Leventhal of Leventhal, Puga, Brayley, PC, Justice Bernard Gluckstein from Gluckstein Lawyers, Justice Kate Deakin from BLG, Justice Brianna Young from Torkin, and finally Justice Jan Marin from Gluckstein Lawyers presiding. Justices of the panel, I present to you, speaking on behalf of the appellant, Mrs. Armstrong, in today's matter before the court, Emma Aggett and Tony Pascale, and speaking on behalf of the respondent, Dr. Ward, Kia Anderson, and Renee Taillieu. We are here today to determine the outcome on appeal before the court on the matter between Mrs. Armstrong and Dr. Ward. Both the appellant and the respondent's counsel will have 30 minutes each in total, 15-minute each counsel member to present their arguments to this court, including answering questions from the bench. The appellants will present their arguments first, followed by both respondents, and then a 3-minute rebuttal will follow by the appellant. I will signal to the court when there is a 5-minute left per speaker by way of this card. Appellants, will you be using your 3-minute rebuttal?
Yes, we will be.
Thank you. The court now invites counsel for the appellant to begin.
Good afternoon, Justices. My name is Emma Aggett, and I am counsel for the appellant in this matter, Karen Armstrong. Our submissions today will demonstrate why the Court of Appeal in this case reached an incorrect finding that the trial judge erred in his articulation and application of standard of care. I will be dealing with the first two issues of requisite standard of care and of duty to rule out non-negligent causes. My co-counsel, Tony Pascale, will then make submissions on causation and standard of review. Altogether, our submissions will demonstrate why the court should set aside the judgment of the Court of Appeal and restore the trial judgment with cost throughout. My submissions have three main points. One, the standard of care for medical practitioners in Canada is clear, and the trial judge correctly defined the standard of care based on the evidence provided to him at trial. Two, the trial judge was not using a goal-oriented approach in defining standard of care. It is our submission that goals and steps are purely semantics in this case. And three, the plaintiff does not have the duty to rule out all possible non-negligent causes. My first point starts with this honorable court's holding in Terneuzen versus Korn regarding standard of care. It is well settled that physicians have a duty to conduct their practice in accordance with the conduct of a prudent and diligent doctor in the same circumstances. In this case, the trial judge was asked to determine what that specific conduct would entail. Based on the expert testimony of 5 medical professionals, including Dr. Ward himself, the trial judge appropriately concluded that identifying, protecting, and avoiding direct contact or close proximity to the ureter are essential steps a surgeon must take in conducting a laparoscopic colectomy. The majority at the Court of Appeal found that the trial judge accepted Dr. Ward took on required steps to meet the standard of care, and thus should have resulted in a finding of non-negligence. With respect, this is simply not true. The trial judge heard multiple expert witnesses and established steps required to meet the standard of care based off of their testimony. The trial judge explained at paragraph 109 that he was satisfied that Dr. Ward took steps during this laparoscopy to identify and protect the ureter. Took steps, not took all steps. This is because the trial judge had one more required step: to identify, protect, and avoid close proximity or direct contact to the ureter. Close proximity meaning 1 to 2 millimeters away. The trial judge rejected Dr. Ward's argument that he stayed at least 5 centimeters away from the ureter at all times. He provided 2 explanations as to why he rejected this argument, both completely supported by the evidence of the expert witnesses, which I will touch on later in my submissions. Moving to my second point, the majority at the Court of Appeal found that the trial judge erred in focusing on goals rather than the means to achieve goals in performing a colectomy. The majority found that the use of the word goal was inappropriate as it implies a standard of perfection, which my co-counsel will address during her submissions. We respectfully submit that the trial judge's use of the word goal is purely semantics. Goals and steps can be used interchangeably when describing what one must do during surgery. Of course, there are steps a surgeon must take in a specific surgery. Completing those steps successfully can be described as a goal of the surgeon. I'll echo Justice Van Rensburg in dissent when I say that throughout the trial, staying away from the ureter was consistently described by the witnesses as a step Dr. Ward should have taken and not his goal.
Excuse me, counsel. Isn't a goal something that's sometimes achieved but not always achieved?
Thank you for your question, Justice. So, exactly. And that's why we're saying that in this case, this wasn't, a goal. This was a step. And of course, the trial judge did refer to it as a goal at one point. But also, if you do look through the trial judgment, he consistently does refer to it as a step at other points throughout the judgment as well. Additionally, all of the expert witnesses refer to it as a step. So I'm pretty sure it was clear that it was known to be a step.
The reason I asked the question is because you said the use of the word goal and step could be used interchangeably. But if a goal is something that is not always achieved, and a step, as you said, is essential, aren't these two things that cannot be used interchangeably?
Thank you, Justice. While I acknowledge that's true, if we really dive deep into definitions, when people are kind of talking about I use this example in my factum, my goal is to get an A on the exam. And the steps I'm going to take to get an A is to, I'm going to study every day. Maybe my goals along the way are to make an exam review. Like I can say that's either a step of mine in the process or, that's one of the goals along the process to achieve the main goal. So I guess it depends how technical you want to define it. But I think it's just because everyone else was consistently referring to it as a step that we need not really dive that deep.
But counsel, you would agree if we are of the view that the judge did mean goal separately from what a step is, that is something we could review? Would you agree with that?
If he did mean goal of,
Yes. And I'll tell you why I'm asking.
Okay.
So that you don't think I'm trying to trap you. We're at a reviewing court, an appellate court. We can't know what is in a judge's mind. So the best way for us to figure that out is to see what that judge writes. Is it not?
Yes, I completely agree. I do completely agree. Although, since all of the expert witnesses were testifying, this is a step, they were asked, what are the steps to meet the standard of care? They gave their answers, including the defense expert witnesses said, protecting and avoiding contact with the ureter is a step. So whether or not the trial judge interpreted it as a goal or maybe said that it was a goal, all of the evidence pointed towards it being a step. And as Justice Van Rensburg said in dissent, this was never, an issue at trial. It was clear amongst everyone.
I just add, isn't the issue here basically credibility? The judge accepted the evidence of the plaintiff's doctors and rejected Dr. Ward's evidence. And having found that as a fact, coming within 2 millimeters of the ureter in itself was negligent. Could you address that?
Sorry, Justice, I'm just having an issue understanding what your question is. Can you repeat, please?
Well, I'm trying to make it simple for you because as I see this whole case boiled down to a question of credibility. Who did the judge believe as far as the experts? And I'm trying to assist you in your argument to get to the main issues of the case, which was a matter of credibility. So can you address that?
Yes, thank you, Justice. So in terms of credibility, he found that all expert witnesses were pretty obviously credible in their responses. And if you actually look within the testimony of the defendant's expert witnesses, Dr. Hagen, he is a surgeon called by the defendant where he reiterated that the standard of care was to identify and protect the ureter, which he claims that would ensure the ligature would not come within 2 millimeters of the ureter had these steps been taken. Dr. Robinette, he is also an expert witness who testified on behalf of Dr. Ward, stating that the standard of care required Dr. Ward to find the ureter and stay far away from it, not to damage it. So I think it was pretty consistent throughout all of the expert witness testimony that staying away from the ureter was an essential step. In terms of credibility, the reason why the defendant's argument was rejected is because they could not put forth any evidence that the non-negligent causes they were suggesting were even possible. So they did bring forth a few non-negligent causes suggested by the expert witnesses, but they could not point to a time where they had ever seen it happen in their career. They could not point to a time in the medical literature where they have ever seen it. And as Dr. Colt said for the appellant in this matter, he was an expert witness that testified for the appellant, and he said, the ligature is a device that is used all around the world and has an excellent safety record. So surely we would have heard if this potential non-negligent cause had actually had a possibility. Yes, Justice.
Our job is to focus the issues. So let me ask this. Is there any dispute that the injury to the ureter was a thermal injury?
No, Justice.
Was there any dispute that the only instrument that was being used that could have caused that injury was the ligature?
Yes, so Justice, I will explain what happened to better assist my answer, but it was never disputed that it wasn't a thermal injury. So this is how the ligature works. Essentially, there's two prongs and
Excuse me, I don't mean to interrupt you, but was there any dispute that the injury was caused by the ligature? Not how it works, but it was actually caused by the ligature. Did the two sides dispute that?
There was no dispute because it was a burn and there is no other instrument that could have caused this type of damage.
And finally, was there any dispute that in order to cause the injury, the ligature, this instrument in Dr. Ward's hands, had to be within 2 millimeters?
There was dispute, yes. And that's when the defendant submitted a non-negligent claim where they said that this burn could have occurred from 5 centimeters away. And that's what I'm saying was not supported by evidence. The expert witnesses said that they never seen this actually occur. They couldn't point to any literature that would suggest that it had occurred.
Also, didn't the judge reject Dr. Robinette's explanation of previous scarring tissue or scarring tissue developed because of the ligature in another area? He rejected Dr. Robinette's explanation as to what could have caused the injury to the ureter.
This is correct. Yes, he did reject that. Yes. And Dr. Robinette was, you know, a expert witness for the defendant, and it was rejected.
Counsel, I'd like to know what your position is on your friend's submission that essentially the evidence in this case leads to the conclusion that you're requiring perfection of Dr. Ward. Once all of the risk factors have been ruled out, all you're left with is that this injury should never happen. Is that not, in essence, a standard of perfection?
Thank you, Justice, for your question. So my co-counsel, she is going to address this more in depth, but to kind of give you an answer right now, even if there was a 0.01% chance that this non-negligent theory was possible, if Dr. Ward could point to one instance where he's seen it occur, or any of the other expert witnesses could point to one instance in their practice or in the literature, then I'm sure it would have been taken more into consideration by the trial judge. But because they couldn't point to any type of negating evidence, this is why it was rejected at trial. I hope that answers your question, Justice. So I recognize that I'm running out of time, so I'm just going to quickly go through my third and final point. So the plaintiff does not have the duty to rule out all non-negligent causes. This theory would create an infinite amount of duty on the plaintiff, from earthquakes to muscle spasms to the hospital losing power mid-surgery. If these non-negligent theories are not argued by the defendant, surely we can assume it's because the evidence did not support that they occurred. Not to mention, in medical malpractice cases, the defendant is surely in the best position to bring forth non-negligent theories, considering that the plaintiff is often sedated and often does not have the expertise to know what is happening regardless. So this honorable court held in Danny Look versus Ainsworth Technologies that litigants are only entitled to one bite at the cherry and are required to put their best foot forward to establish the truth of their allegations when first called upon to do so. So this doesn't really align with what happened here, because at the Court of Appeal, new non-negligent causes were brought forth. And the majority was asking, why didn't the trial judge consider these non-negligent causes? It's because they were not brought up by the defendant at trial. And
Counsel,
based on, yes.
Sorry to interrupt. If there is this almost a burden, do you see it as a shifting burden of proof, that there's ultimately some burden placed upon the defendant in these cases?
Thank you, Justice. No, I would not agree with that. I don't think the burden of proof ever shifts to the defendant in these type of cases. What does happen in these type of cases is the trial judge is presented with direct evidence and circumstantial evidence. The plaintiff is able to put forth their evidence to prove negligence. The defendant then has the right or must bring forth their negating evidence. And then based on the defendant's negating evidence and the circumstantial and direct evidence before them, the trial judge can weigh whether the defendant's evidence actually does negate the plaintiff's. And simply put, in this case, that's just not what happened. He didn't find that it did negate.
But aren't you just saying that once the plaintiff establishes a prima facie case, then the onus is on the defendant to establish alternative causes? And that's basically what Judge Van Rensburg said, Justice Van Rensburg. So there is an onus on the defendant to rebut the prima facie case of the plaintiff.
Correct. Thank you, Justice. So what I'm making reference to here is this court's holding in Fontaine in 1998. So in that decision, they said the plaintiff obviously does have the burden to prove negligence. They must bring forward proof, and the defendant must then present evidence negating the plaintiff's evidence. And I think that's only fair in medical malpractice cases, especially when the defendant has the benefit of knowing what happened in a more complex matter than the plaintiff would. So the trial judge obviously does have the discretion once they have both evidence presented, which one they find is more valuable and more believable. Yes, Justice.
Question. You indicated to us as part of your argument that Dr. Ward was taking a position that even though he was 5 centimeters away, that could have resulted in an injury. Didn't Dr. Ward simply say he was 2 to 5 centimeters away, not millimeters, but 2 to 5 centimeters away, meaning that he could not have caused an injury? Wasn't
Correct.
that the position?
This is the position, and I think that's the main issue in this case. Dr. Ward, he said that he never came within even 5 centimeters, and obviously the space for burning is the 1 to 2 millimeters, and this is why the trial judge actually had to look at what happened in order to not determine standard of care in this case, but just to help define it, which my co-counsel will further explain in her submissions. But this is the thing, from 5 centimeters away, the type of burn that occurred and the scarring that occurred could not have happened simply based on the evidence put forth at trial. And I believe this is why his argument was not accepted by the trial judge. I notice I'm out of time, so I'm going to pass the floor to my co-counsel, but thank you very much for your questions today, Justices.
Good afternoon, Justices. My name is Toni Pascale, and I will be dealing with the second 2 issues on causation and standard of review. I have 2 points on my submission. First, the trial judge did not err in using circumstantial evidence to inform the standard of care. And second, the majority erred in applying a correctness standard of review rather than a reasonable standard of review. My first point follows that causation can be considered as circumstantial evidence to inform the standard of care. The issue at appeal surrounds the fact that the trial judge analyzed the cause of Miss Arm's injuries before concluding that Dr. Ward breached the standard of care. The trial judge is to determine whether there was a breach in the standard of care before addressing causation. However, in some instances, determining what happened and how it happened could be relevant circumstantial evidence and help determine if there was a breach of the standard of care. They had to analyze what happened to figure out if Dr. Ward did the thing he said he did not do, come within 1 to 2 centimeters of the ureter, and they had to do so on a balance of probabilities. In Kennedy versus Jackowitz, the court held that it is nonetheless open to experts and to the court to draw inferences of fact. It may be appropriate then for an expert of the court to infer from the nature of the injury what it was the surgeon did. There were a few possible explanations of how Miss Armstrong's injury occurred that the trial judge assessed. The first was that Dr. Ward breached the standard of care and brought the ligature within 2 millimeters of the ureter. And the second was that he remained a safe distance. However, scarring occurred and traveled through the abdomen, causing damage to the ureter. These causes imply a very different explanation of Dr. Ward's actions during the surgery. Considering these potential causes, the trial judge had to rely on the outcome of the case, looking at the nature of the injury to determine whether Dr. Ward met the standard of care. These potential explanations are simply theories that are not found within academic literature. With respect, the court's role is not to hypothesize about explanations not found within evidence. The court must consider the evidence on a balance of probabilities, which is what the trial judge did. Considering the lack of first-hand evidence from expert witnesses brought forward by my friends, the more probable explanation is that Dr. Ward came within 1 to 2 millimeters of the ureter with the ligature. The majority held that this would be an appropriate analysis of the standard of care in this case, as thermal injury was circumstantial evidence of what happened. However, the majority held that the trial judge erred in considering the standard of care, leading them to state that causation would not have been an independent error in analyzing the case. In other words, the majority did not find issue with the fact that the trial judge considered causation in determining if standard of care was breached. My friends also argue that using causation to define the standard of care risks creating a standard of perfection. First, the trial judge did not use causation to define the standard of care. This is not what we are arguing. The trial judge used it to inform the standard of care. The trial judge also did not impose a standard of perfection. He found that although Dr. Ward maintained following the steps required to meet the standard of care, he had not met the final step required, staying 2 millimeters away from the ureter, which is proven by the injury. The trial judge heard expert witness testimonies from 5 doctors, including Dr. Ward himself, all who agreed that the standard of care is to identify and protect the ureter, and the way in which you protect the ureter is by staying 1 to 2 millimeters away from it. This finding was supported wholly by the evidence provided at trial. Staying 2 millimeters away from the ureter was not a goal of this surgery, but an essential step. Using circumstantial evidence disproves the fact that the trial judge expected perfection. In fact, the trial judge rejected the statement that there should be 0% chance of injuring the ureter if following these steps because he did not want to impose the standard of perfection. It is argued that the trier of fact must consider what was done if what was done breaches the standard of care, not use the evidence of what happened as the standard of care. Yes, Justice.
Did the trial judge make a determination that in this case, considering the circumstance of this case, that there were no risk factors, that in this case, the injury should not have occurred if Dr. Ward followed the standard of care? And by him saying that because of in this case, had he done what that essential step required, the injury would not have occurred. There was a 0% chance.
No, so this was Dr. Bernstein that suggested that there should be a 0% chance of risk. And the trial judge did reject this because they didn't want to impose the standard of perfection. So the trial judge admits that this surgery obviously has risks. Every surgery has risks, but he did say that it was low risk. There was very limited opportunity to damage the ureter on a surgery on a person with an anatomically normal colon. And that was the facts around Miss Armstrong's colon. It was anatomically correct. So there should have been a very low risk of injury to the ureter. And his own expert witnesses suggest that if you stay 1 to 2 millimeters away from the ureter, there should be no risk to the ureter. I hope that answers your question. The trial judge simply expected.
Sorry, I'm just going to interrupt. Pardon me. I'm interested by the language you used. There should be no risk. How is that not perfection?
So,
or where's the wiggle room is what I'm trying to figure out.
The trial judge said there should be a low risk. The expert witnesses said that if if Dr. Ward remained the 1 to 2 millimeters away, that there wouldn't really be an issue. There wouldn't be an injury to the ureter. but the trial judge rejected the issue of the statement that there should be no risk because they didn't want to impose a standard of perfection. They said that.
But is it not? Tell me, where's the distinction? If there's a position that remaining 1 to 2 millimeters or centimeters, I've now lost track, away should never lead to a thermal injury, and there's a thermal injury, it must mean that you are within that range. So isn't that a standard of perfection by saying, oh, thermal injury, therefore there's only one way to do this, stay a certain distance away? No, you're saying.
Thank you for your question. So of course, mistakes happen in surgeries. Obviously, there are issues. As my co-counsel suggested, if an earthquake happened during the surgery, then obviously that would be out of the defendant's hands. But this was very much so in Dr. Ward's hands to identify and protect the ureter. And if he did not do those steps, then he did not he breached the standard of care within the procedure. I see 2 hands.
So let me ask you this. Am I correct that Dr. Ward in the trial did not dispute that if he'd stayed over 2 millimeters away, the injuries would not have occurred?
So Dr. Ward said that he knew that if he had gone within 1 to 2 millimeters away, he said that he believes that in 2010, when this happened, that he knew that. But
So doesn't that answer the question?
I
Doesn't
suppose.
that answer the question that the judge just asked? That if in fact the defendant himself admits that if he's within 1 to 2 millimeters, and I know he denied that, he said he was centimeters away, which are inches away. But if in fact he admits that he's within 1 to 2 millimeters, the injury will occur. If he's outside that, it will not. So whether you call that perfection or not, doesn't that answer the other justice's question?
Yes, exactly. Thank you, Justice.
I just wanted to follow up on Justice Dames's and Justice Leventhal's questions. I'm wondering if this is more properly in the category of the sponge that is left behind, or the wrong operation, the wrong limb that is operated on, and so it is seen as negligent per se, or in a category of itself, rather than, what I view as the legal gymnastics that the trial judge and the Court of Appeal have gone through to try and classify what happened in this case.
Yes, exactly. So I would agree. It's the trial judge. Sorry, can you repeat your question?
I'm asking if this is if this is properly this sort of outcome in this operation, where the ureter is damaged, a healthy ureter is damaged, is in the class of negligence per se, akin to the cases that have recognized when a sponge is left behind after an operation, or the wrong limb is operated on, such that there can be no non-negligent explanation for the injury.
So if there was a non-negligent explanation, then the trial judge has to assess it, of course, which the trial judge did. The non-negligent explanation that was brought forth, the trial judge assessed and rejected because of the lack of academic literature. So in this case, their really only option was to assess the fact that the ureter was burnt by the ligature coming within 1 to 2 millimeters.
Thank you.
So moving to my second point, standard of review is a question of law reviewed for correctness, and the court must consider mixed fact.
Counsel, before you move on, there was a question I had regarding the utilization of causation within the standard of care analysis. So I understand your position that in some cases, it's appropriate to look at what actually happened to inform the standard of care.
Yes.
But do you see there being a distinction between what the standard of care actually is versus whether the standard of care was met? And is it appropriate in your view, and this court is interested certainly in informing counsel in the future, whether that's something that can be used for both elements of standard of care?
So yes, there is a difference between those. So the standard of care was determined by the trial judge after hearing expert testimony. So they knew that identifying and protecting the ureter was the standard of care. And the trial judge obviously then had to look at the circumstantial evidence because they were really given no non-negligent explanation. The non-negligent explanation they were given didn't support the findings. So I would have to say that there's a difference in what the trial judge did. And as for your question of if the court should consider these as separate issues, am I understanding that correctly?
So I'm asking whether it might be appropriate in some cases that the standard of care also could be defined using causation, or whether you're saying that there is a hard line that causation should only be used to determine if standard of care has actually been met.
So I believe that it is our submission that the standard of care causation can inform the standard of care. It should not define it, because then we'll be looking at what happened to determine what the standard of care is. But we can look at what happened to see to help determine if the standard of care was breached, which I think are very different things. I hope that answers your question. So the majority erred in applying a correctness standard of review and should have instead applied a reasonable standard when considering the trial judge's findings. It is important to note that a court of appeal must have substantial reasons for overturning a trial decision and must take more than a different view of evidence into account, which they did not. The majority in Hussein versus Nicolason states that appellate courts must be cautious in finding that a trial judge erred in law in their determination of negligence, and it is often difficult to extricate the legal questions from the factual. Where the issue on appeal involves a trial judge's interpretation of the evidence as a whole, it should not be overturned absent palpable and overriding error. The majority determines that had the trial judge worded the standard of care differently, not changed the meaning, but changed the wording, the submissions would have been accepted by the Court of Appeal without dispute. This is not palpable or overriding, but merely an issue of semantics. In Cooper versus Floyd, the Court of Appeal and trial judge differ in their holding of the case because they interpreted the evidence differently from each other. The court held that it is reasonable for the Court of Appeal to review, re-examine, and reweigh evidence provided, but they must also come to a reasonable conclusion, in which case the trial judge's findings in Cooper was not unreasonable. Like this case, the majority erred in not accepting the trial judge's explanation of the standard of care as a goal. Overturning the trial judge's holding should not occur in the absence of palpable and overriding error. Having differing opinions surrounding conclusions of cases is anticipated. However, the findings of facts will remain the same. As stated in Benim versus Saint Germain, the trial judges are immersed in evidence. They hear viva voce testimony, and they are familiar with the case as a whole. Their expertise in weighing large quantities of evidence and making factual findings ought to be respected. The trial judge had evidence to support their holding. However, the majority did not respect these findings, which usurps the trial judge's role within the justice system. As the dissent states, deference is owed to the trial judge on all findings other than on questions of pure law. The trial judge did not err in their definition of standard of care, as my friends suggest. Rather, the majority disagreed with the phrasing. This is not reason enough to overturn the trial judge's findings, nor is it reason to reweigh evidence presented before the trial judge. Semantics does not constitute as palpable or overriding error, and therefore the majority erred in their application of standard of review, and the court should overturn this decision to reflect that of the trial judge. To conclude my submissions, we respectfully submit that the court should set aside the judgment of the Court of Appeal and restore the trial judgment. The trial judge appropriately considered circumstantial evidence in informing the standard of care and in determining how Ms. Armstrong's injury occurred. The majority erred in applying a correctness standard of review, as disagreement surrounding semantics does not constitute as overriding or palpable error. Subject to any further questions, I realize I'm probably out of time now, but that concludes my submissions.
Thank you, counsel. The court now invites counsel for the respondent to begin.
Good afternoon, justices. My name is Kaya Anderson, and this is my co-counsel, Renee Taillieu. Today, we will be representing the respondent, Dr. Colin Ward. I will begin with a brief roadmap followed by our submissions. So first, I will be explaining why the Court of Appeal correctly fixed the legal mistake that the trial judge made by defining the standard of care as a goal. Second, I will turn to the question of standard of review and why the appropriate standard to be applied is correctness, because the trial judge made a legal error and not a factual error. My co-counsel will then explain why causation should not be used as circumstantial evidence to inform the standard of care. Lastly, she will explain that the Court of Appeal was correct in their statement that that the plaintiff can have a duty to rule out non-negligent causes in certain cases. So beginning with the issue of standard of care, first I will explain how the trial judge erred and created a standard of perfection and why the Court of Appeal was correct in rectifying this error based on the relevant case law. Second, I will clarify why the issue of staying away from the ureter is a goal and not a step, and it's not simply semantics. Lastly, I will shed light on why the court must remain extremely cautious in not implementing a standard of perfection in medical negligence cases. So at issue is whether the trial judge applied a proper standard of care to determine whether Dr. Ward fulfilled his duty to Ms. Armstrong. Unfortunately, the trial judge erred and created a standard based on results and not on means. The Court of Appeal corrected this error and using the trial judge's own factual findings found that Dr. Ward was not negligent. To determine the correct standard of care, one must ask whether the defendant behaved as a reasonably prudent and diligent fellow professional would under the same circumstances. The trial judge began his conclusion with these very determinations and found that a reasonably prudent and diligent professional would take steps to identify, protect, and avoid the ureter in his conclusion using the expert evidence. These steps included checking and rechecking the location of the ureter, steps that the trial judge found Dr. Ward to have followed. However, instead of using these steps as the standard of care, he ultimately and incorrectly concluded that it would be a breach of the standard of care for a general surgeon to touch the ureter or to come within 1 to 2 millimeters of it, making the standard of care dependent on achieving the goal of not coming.
Excuse me,
Yep.
can I just, now, the trial judge found that he could not accept Dr. Ward's evidence. So therefore, if by rejecting Dr. Ward's evidence and by accepting the fact that if you came within 2 millimeters of the ureter, that itself would be a breach of the standard of care. Don't you agree with that?
So respectfully, I would say that it would not be a breach of the standard of care because a step cannot be pointed to other than this goal of not injuring the ureter, which we are submitting is a goal because the steps you take to not injure the ureter would be the rechecking and checking. And those are steps that the trial judge did find Dr. Ward to have taken, if that answers your question.
Just as a follow-up, but didn't all the doctors agree that coming within 2 millimeters of the ureter in itself is a breach of standard of care?
Respectfully, there was 2 experts that said that if your intention is not to come within that 2 millimeters, that if you're taking all the relevant steps, it would be an error, but not necessarily a negligence error. It could be an error of just a unfortunate but result of
Yeah, but understand, Dr. Ward's lawyers did not plead misadventure. They put all their eggs in one basket. And what they said was Dr. Ward stayed within 5 millimeters of the ureter, which would be proper, and that the injury was caused by something else, Dr. Robinette's evidence. So once the judge finds that you came within 2 millimeters or 2 millimeters of the ureter, that in itself would be breach of standard of care. I don't see how you can get around that.
So I think with respect, we are not necessarily trying to get around that, but rather accepting the evidence that would be, it would cause injury, but it's not necessarily indicative of negligence if the steps to not come within have been followed. So Dr. Ward followed those steps. However, something did occur and there was an injury, but that is why I submit that you do the standard of care beforehand before looking at the injury. So when the standard of care was determined using the expert's evidence, that standard of care was found to be checking and rechecking where the ureter was, which is steps and not a goal. If that helps to answer your question, yes.
Go ahead.
So, I'm sorry, go ahead.
No,
So I
I'm
have a
fine. Go
question.
ahead. Tate.
In the opinion itself, it said that the lawyer for Dr. Ward asked several questions and asked whether each one of those statements, if true, meant that for that statement, for that step, the doctor met the standard of care. Is it your position that simply because the doctor met the standard of care for 4 steps, that it wasn't necessary for him to meet the standard of care throughout the procedure and stay further away than 2 millimeters because he met the standard of care at times during the procedure? It wasn't necessary for him to meet the standard of care throughout the procedure or stay away from the ureter by 2 millimeters throughout the procedure.
Respectfully, we would submit that there was no step that can be pointed to that Dr. Ward did not follow other than that goal of staying away, which again, we will reiterate that that is a goal. So if that goal is taken away, then we submit that he did follow all of the steps that the trial judge found and listed in the beginning of his conclusion.
Let me follow up on that. The testimony at the trial was that it was an essential step, not something that may or may not be achieved, but an essential step to identify and make sure that the surgeon is more than 2 millimeters away. That wasn't a goal. That was what the surgeon was required to do. It's like saying, look before you cut. Look before you use the ligature. If in fact the doctor did not stay 2 millimeters away, because as he stated, gee, there were times during the procedure I might not have been able to see it. I may not have been able to see the ureter. Would that indicate that the standard of care applied by the trial court was appropriate, that he was required, it wasn't optional, required to stay at least 2 millimeters away? And the circumstantial evidence, the footprint in the snow, is that he got to within 2 millimeters. Therefore, there was a breach of the standard of care.
So respectfully, we believe that the standard of care, if you take away that goal, then the standard of care was followed. And I think respectfully, you could say that every step is a goal and don't cut too far here, don't cut. So I think that if those steps were correctly, if they were put into the correct legal standard of care, then they would have been found to be followed.
Let me ask one more question. If a surgeon at the end of every procedure simply said that I met the standard of care, wouldn't that place an undue burden on the victims of medical negligence, those people injured, catastrophically died, etc., for ever bringing a medical malpractice case because the surgeon said, you know, it was a goal, but I met the standard of care? Wouldn't that place an undue burden on victims?
It certainly would, and I would submit that that is not what is happening in this case. I would submit that here, simply, this is a case of a doctor following all of the steps that have been articulated, and it is not a case like you have just mentioned. And I think that it kind of highlights the reason why we must look at the standard of care before we look at these very tragic and catastrophic injuries, because they can occur despite any negligence occurring. It can be a simple error. And I believe that the trial judge did leave that door open, that there can be an error, even when the colon is anatomically normal, and even when when a doctor is following the standard of care.
I have one more question, I apologize, but
That's
in the trial, the doctor said it may have been an accident. Can you please just explain to us the difference between an accident, which happens when somebody's not paying attention, and substandard medical care?
Certainly. So I think the difference would be looking at, again, the steps and the standard of care articulated by the other medical professionals. And if that had been correct, if the legal error in that had been corrected, then that would be the difference in our submission. So So my co-counsel will be expanding on the dangers of hindsight bias in her submission. I've touched on them briefly here, but it's important to remember that we are here to assess the means that Dr. Ward took and not work backwards from the injury. So the applicants have stated that this was like surgery 101, but we cannot assume that a medical error cannot happen, or else that would be a standard of perfection. And the case law is incredibly clear that a standard of perfection is a legal error. So for example, the Supreme Court of Canada in St. Jean and Mercier cautioned against using the erroneous goal-driven approach because it runs the risk of focusing on the results rather than the means. And professionals have an obligation of means, not obligation of results. And that same sentiment was echoed by the British Columbia Court of Appeal in Carlson and Sutherland. So in that case, the facts were very similar to ours. The trial judge inferred that because the surgeon had inadvertently cut blood vessels, that a negligence case was prima facie established. So the BC Court of Appeal corrected this trial judge's formulation of the standard of care and reversed the finding. So subject to any questions on that issue, I will turn to my second.
I have just a very quick question about
Certainly.
this distinction between obligation of means and results with respect to doctors. Is that also true for elective surgery or like plastic surgery? Is it just a means obligation?
I think it would certainly be fact dependent, and especially in a case of plastic surgery, a result could be part of that, but I think that results would be achieved by a standard of care, like the same standard of care. So I think it does stay the same. However, that may play a bigger role in how you define what the steps actually are, and that would, I think, be very factually different depending on every case that occurred in. So subject to any more questions, I will turn now to standard of review. So briefly, I will explain why the applicable standard of review for the issue at hand is correctness. And it's correctness because it is the standard of review for legal errors. Second, I will explain why this is a legal error and not a factual error or a question of mixed law and fact. So the issue at hand is an error of law, the error being that the trial judge erred in defining the standard of care that Dr. Ward had to meet and improperly established a standard of perfection. It's clear from the case law that the appropriate standard of review for legal errors is correctness, and the authority for this being Howson and Nicolason. So also citing Howson, the applicants have proposed that this issue is one of mixed fact and law, subject to a review of palpable and overriding error. We submit that is an incorrect interpretation of the issue at hand. The issue is clearly a legal error because it involves the legal component of a standard of care, not the factual findings of the trial judge. And in fact, the factual findings of the trial judge have been shown deference upon appeal. The Court of Appeal stated that they accepted the judge's factual findings, and they even stated that if the error in the legal standard was corrected using the factual findings of the trial judge, that Dr. Ward would be found not liable. So questions of mixed fact and law are questions about whether facts satisfy the legal tests. And here the question is about the legal test, here being standard of care. So Howson highlights that what appears to be a question of mixed fact and law can be a purely legal question in circumstances of negligence findings that rest on an incorrect statement of the legal standard.
Excuse me.
Yes.
Is the standard of care is that a legal determination or medical determination? I mean, doctors go to medical school for years to learn how to practice medicine and what to do. Why is the determination of standard care a legal determination rather than a judge simply making a determination, a finding as to what, based on the evidence, the standard of care actually required?
So certainly we submit that it is up to the trial judge to listen to the evidence of the experts and determine what the standard of care looks like in those circumstances. But here the error was how the judge defined that standard legally and did not use steps, but rather a goal. So we would submit that that the standard of review must be correctness then, because it is not applying the facts to the standard of care. It's more about how the judge defined the standard of care and the legal error that has been described in the case law countless times, that a judge cannot make a standard of perfection. So just to conclude, the court of, I see now that my time has lapsed, so I'll quickly just, subject to any remaining questions, conclude my submissions and hand the floor over to my co-counsel, Renee.
Good evening, Justices. My name is Renee Taillieu, and I am co-counsel for the respondent physician, Dr. Colin Ward, along with my co-counsel, Kaya Anderson, who just spoke. I will now present our next two arguments. First, I will argue that the Court of Appeal was correct in their finding that the trial judge erred in using causation as evidence to determine the standard of care. Second, I will argue that the Court of Appeal was correct in their statement that a plaintiff can have the duty to rule out non-negligent causes in some cases. First, I will address the issue of conflating the causation analysis with the standard of care. The trial judge incorrectly used causation as evidence to inform the standard of care, and the Court of Appeal appropriately identified this error. Tort law is grounded on the principle that the elements of negligence must be found sequentially, and that if one element is not proven, the analysis cannot proceed. Thus, causation can only be examined once a breach of the standard of care has been found. Despite his correct statement that courts are required to determine what the standard of care is and whether it has been breached before analyzing causation in light of such a finding, the trial judge went on to use the inference that Dr. Ward caused the injury to Ms. Armstrong's ureter to inform the standard of care as being to identify, protect, and avoid direct contact with or close proximity to the ureter. Justice Pacheco correctly identified this error, finding that had the trial judge applied the correct standard of care, he would not have needed to conflate the issue of causation with the standard of care decision. Generally, the use of causation as circumstantial evidence to inform the standard of care has largely been rejected. In McCardle Estate and Cox, the court stated, "It is a critical fault to reorder the negligence analysis by placing the causation analysis before that of the standard of care. How can a judge decide whether, but for the defendant's substandard action, the plaintiff would not have been injured, if the characterization and application of the standard of care decision depends on the causation decision? The suggestion that causation," oh, I see there's a question. Yeah.
Thank you. So are you saying that since the standard of care, as you are arguing, is sequential, that once a doctor said, I operated on the right patient, I did the right surgery, and I took a step or steps during the procedure, that what happened as a result of the procedure is irrelevant?
I wouldn't say it's irrelevant. I mean, of course, all of the expert testimony at trial will be regarding whether what happened during the surgery was negligent. But in our submission, the trial judge placed too much effort on the causation analysis. So he essentially used the fact that he found the injury to have been caused by the ligature to define the standard of care as don't cause the injury with the ligature.
But wasn't the analysis by the Court of Appeals that once Dr. Ward testified that he met the standard of care for certain steps of the procedure, that was the end of it, and what happened was irrelevant? Wasn't that his analysis?
So, it looks like we have another question, but I'll answer this one first. So in our submission, we do agree with the Court of Appeal that, I mean, in all negligence cases, negligence is a sequential analysis and the standard of care should be determined first. So we do agree with the Court of Appeal there that once there's a duty of care owed, which of course is owed from healthcare professionals to patients, and the standard of care is set and it's found to have been met, then the case stops and doesn't move on to the causation analysis, which we would agree with.
Even if a sponge is left in a patient or it's discovered later that something was severed, like an artery, even if the doctor said, I took all the necessary precautions, and it's later discovered that a sponge is left in or an artery is severed or something occurred which gave rise to a horrific injury, the analysis stops once the defendant says, I met the standard of care.
So there are some cases that the appellants raised, such as Grass and Maringolo, where the Ontario Court of Appeal did find that it was appropriate to bring in the injury into the standard of care analysis. But the Ontario Court of Appeal later clarified in Chantry and Warbeck that these two cases were a very rare exception, and that this analysis should only be conflated in those cases that are just so obvious, such as leaving a sponge in, like you had provided an example in your question.
Thank you. My question was precisely about that. In what circumstances can the causation analysis inform the standard of care analysis? And at the end of your answer to Justice Leventhal, you said, it's just so obvious that it informs the analysis. And I'm asking you, isn't this the case here? If the only explanation that we seem to have for the ureter being damaged is proximity within 2 millimeters, isn't this a case where precisely where causation should inform the standard of care analysis?
So we would submit that in this case, it was not as obvious that it was caused by negligence as the case of, say, the surgeon having left a sponge in the patient, as the trial judge refused to accept that the risk of injury was 0, and none of the experts testified that the only way it could have happened would have been negligent. I mean, Dr. Ward said himself that the risk in these surgeries is never 0, but that it wouldn't necessarily mean that it was negligent, even if he did come within 2 millimeters of the ureter, because having it be performed laparoscopically, sometimes just how those surgeries work, the ureter will be out of view, although the standard is for the physician to try as much as possible to make sure that they don't hit the ureter, that sometimes it is out of view, and that they could potentially injure it, but that it still would not be negligent because they took all the steps that they were required to take.
Was there any literature that actually supported that statement, that during a laparoscopic procedure, it's okay to use the ligature, this tool that can burn tissue when you can't see the tissue?
I'm not aware of literature that talks about the acceptability of using the ligature when you can't see it, but I do know that this ligature is used, thousands of times by Dr. Hagen alone during laparoscopic colectomies. So I would assume, just based on the amount that it's used, that it is accepted. But there was an article by the Society of Obstetricians and Gynecologists that stated, although identifying and attempting to re-identify the ureter will significantly reduce the risk of hitting it, that the risk in these surgeries is never 0.
Yeah, but the evidence at trial was quite different. The evidence at trial was that Dr. Ward said that he always stayed outside of 5 millimeters away. That was his argument, and that's what the defense based their argument on, and that was rejected. So talking about whether or not he could see the ureter during the procedure or not, that's irrelevant. The relevant thing was that the ureter was damaged, and that the judge found the ureter was damaged because he came within 2 centimeters of the ureter. And everybody agreed that would be a breach of the standard of care. How do you get around that?
So our submission is not arguing with the finding of fact the trial judge made that he did come within 1 to 2 millimeters. Our submission is that doing so would not result in negligence. It would be a rare surgical error, and that the error in this case, the issue that we're appealing, is that the trial judge incorrectly defined this standard of care as results-based instead of what the reasonable physician would have done. So we disagree with the appellants that staying away is a step, and we argue, as my co-counsel had said, that staying away is a goal. Yes, Justice.
One more question. Dr. Ward said that if he came within 2 millimeters, it was an accident. Can you explain for us, please, the difference between an accident, and I asked this question before a minute ago to your co-counsel, but an accident where someone's not paying attention and substandard care? What's the difference between those two?
So I'm not sure I'll have a great answer to this question, but I would say that an accident is something that occurs regardless of the physician meeting the standard of care. So if the standard of care was defined as identifying the colon and the ureter, dividing the mesenteric arteries around them, and identifying and re-identifying during the surgery and attempting to stay away, that would be the standard of care, and to do so would be an error. But if the justices accept that not touching the ureter is a step, then Dr. Ward's would have fallen below that. So essentially negligence is falling below the standard of care, and an accident is meeting the standard of care, but the injury still occurred. Does that answer your question? Okay. So this error illustrates the phenomenon of hindsight bias, which manifests in the tendency to exaggerate the extent to which a past event could have been predicted beforehand. Since medical malpractice cases always examine the care of the physician retrospectively, judges and jurors ought to be mindful of hindsight bias when rendering a verdict. Warnings of hindsight bias are well established in the jurisprudence. In Johnson and Hayter, the court stated that the injury itself cannot be a factor used to dictate a finding of negligence, because even though the injury occurred, it could have occurred when the surgeon was using the utmost care, and it is the level of care that is at issue in a malpractice case. In Terneuzen and Korn, Justice Sapinka emphasized that courts must not, with the benefit of hindsight, judge too harshly doctors who act in accordance with the prevailing standards of professional knowledge. For the trial judge to use the injury to Miss Armstrong's ureter as evidence Dr. Ward breached the standard of care was contrary to the warning in Lapointe and Hôpital Le Gardeur that courts should be careful not to rely upon the perfect vision offered by hindsight. Otherwise, the doctor will not be assessed according to the norms of the average doctor of reasonable ability in the same circumstances. Yes, Justice.
Didn't the court make a determination based on an agreement between both sides that it was non-disputed that this injury would not occur unless this ligature, this thermal instrument, was 2 millimeters or less away from the ureter? And if so, how is that hindsight bias if you're looking not at the injury and saying, well, it happened, so something must have gone wrong, but rather applying the facts of this particular case and the agreement by the parties that this injury only occurs when the instrument is 2 millimeters or less from the ureter? How is hindsight bias?
So our argument with regards to hindsight bias was more of a warning rather than arguing that that's something that exactly happened in this case. And it was sort of related to the fact that the trial judge relied on the causation to define the standard of care, and essentially looked at the injury, the ligature caused the burn to the ureter, to define the standard as don't cause that injury. So that's our submission with regards to the hindsight bias. Kind of like I said earlier, it was more of a general warning to the courts than something that specifically happened in this case. So this error was also similar to one identified in St. Jean and Mercier, where the Supreme Court upheld the Court of Appeals finding that the trial judge erred in using the injury to define the standard of care. So the Supreme Court in that case stated whether a specific positive act or an instance of omission constitutes a fault is to collapse the inquiry and may confuse the issue which runs the risk of focusing on the results rather than the means. As my co-counsel stated earlier, professionals have an obligation of means, not result. The error in this case occurred when the trial judge conflated the standard of care and causation analyses, using the result to define the standard. The trial judge used the injury to the ureter, which he said was caused by the ligature, to define the standard as don't injure the ureter with the ligature. So I believe I'm out of time. Yeah. Okay, so that concludes my submission.
Thank you.
Thank you, counsel.
Thank you, counsel.
So the court now invites counsel for the appellant to begin their 3-minute, optional 3-minute rebuttal.
Hello again, justices. Thank you. I would like to point out that if the Court of Appeals decision is upheld, as mentioned by Justice Leventhal, I'd like the court to imagine what a dangerous precedent this would set for plaintiffs in medical malpractice cases. Doctors arguing that they tried their best to avoid damage would be good enough to deem them not negligent. Plaintiffs are already at a disadvantage in medical malpractice cases as it is. Imagine how hard it would be for them to prove negligence after such a holding. Second, I would like to reiterate—
Counsel, just on that point, is there not an equal risk that if doctors will be found negligent so easily, they simply might not accept to do these kinds of operations or tricky operations?
Thank you for that question. While that is possible, if I just think the percentage of plaintiffs that actually win medical malpractice cases is already so low as it is. And in these cases, like, it's so rare to have a case where, everything was perfect. The patient had an anatomically normal colon, everything was in view, standard of care was clear, you've done this surgery multiple times. I don't think the doctor would have issue thinking, I might get sued if I do this properly, if I don't do this properly. So second, I would like to reiterate the submissions of myself and my co-counsel when I say that the trial judge was not imposing a standard of perfection. We acknowledge that obviously the risk was very low, but low risk does not mean no risk. When the defendant cannot show the court a non-negligent reason that aligns with the damage and is supported by the evidence, then how could the trial judge accept such an argument? Additionally, I'm probably running out of time. So finally, with respect to semantics, steps, goals, outcomes aside, no one ever submitted that not damaging the ureter was an outcome of a laparoscopic colectomy. Of course, this wasn't the outcome. The outcome was to remove the colon. Protecting the ureter was a step in this process. If this was a question of pure law, not fact, as our friends submit, a new trial should have been ordered. The trial judge's finding should not have been overturned. And this would conclude my right to reply pending any questions.
Thank you, counsel. This concludes the matter of Armstrong and Ward.
Can we make some comments?
Yes, please. Go ahead.
Yeah, excellent presentations. Your people who were respondents had a very, very difficult case. And we had a real rough panel here. Much difficult than we had at the Supreme Court of Canada. So you guys did very, very well. And, Jan can talk a little more as to what happened in the Supreme Court of Canada, because she was there on this particular case. And we actually were surprised in the Court of Appeal that we lost. We just couldn't believe it. And then when we went to the Supreme Court of Canada, it was almost like we didn't even have to argue. They were all over the respondent and with very difficult questions. And so the final result was that they just adopted the dissenting opinion in the Court of Appeal. So Jan, you can talk a little more about that. But you did very well in view of this panel, I'll tell you.
Yeah, everyone did really, really well today. I echo some of Bernie's comments for sure. The respondents' arguments, especially in light of the determination of the Supreme Court, obviously that was a difficult position to have to take in light of all of that. That being said, I think everyone handled all of the questions well. Of course, being the appellant in this case, a lot my questions were harder for the applicants because I've thought so much about all of the ways that we could be questioned about difficult things, and I also didn't want to go too hard on the respondents, knowing how things may turn out. But everyone did a great job, and I think probably I know my friends for the respondents said maybe they were going to learn a few things over this weekend. They did some judging as well. So it'd be interesting to hear what they have to say about it. But everyone did a great job with interventionist judges for sure.
So I'd just like to compliment everyone. I think you really, really did a good job with a very difficult case. I have some suggestions that should apply in everything you do as a lawyer. When you look at a case, whatever side you're on, look at the other side and identify the landmines. Identify any particular issue that could come up. Like the question I asked, what's the difference between an accident and the standard of care? Should the court be determining the standard of care, or is that a medical decision? What's the consequence of a decision like that? And when you do that, in every case you do as a lawyer, for the rest of your career, you'll be ready for an answer and be able to point it out, respond immediately and with confidence. This is a really, really difficult case to defend. It really is. And the fact that the Court of Appeals decided the way they did is really surprising to me. But having said that, the fact pattern was a great fact pattern for this moot court. I'm impressed with the way you all handled it on both sides. And I know that all of us, all the judges here threw some curveballs, but that's what we were supposed to do. So this can be both an experience in presentation, but also an experience in learning. And I hope that we added something to your education, because I see a great future, not good, but a great future for all of you. So thank you.
I could offer a few just little tips that might help you become even better than you already are. So I loved how all of you road mapped. That's wonderful. It really helps a judge. And I thought for the most part, the pacing was also very good. Very important to allow the judges to keep up with your argument. Of course, you know your argument so well. A judge doesn't know your argument. So keeping that pace slow, and I thought you did a very good job of that. One thought that, or maybe two thoughts that came to mind is, and this is something to practice maybe, you never really want to show the judge when you're on script and off script. And some easy tip-offs is when your language changes. So you have a script where you have perhaps a formal approach, and then when you're questioned, you suddenly turn into a more informal. For my taste, I think if you could find a happy medium, that way the judge is always believing they're in a conversation with you. And that's what really good advocacy is. The judge has a question, something's perturbing them. It's your job to mollify that. So you've just started in law school. I suggest you use every opportunity to develop your voice, the voice that you want to use, whether you're on script or off. What I would urge you not to do is to incorporate horrific legalese into your everyday life and language. Just don't do that. But simple, but not simplistic language, very clear way of expressing yourself will endear you to the bench, because they love hearing somebody talking to them, not talking at them. So I would say, for the most part, that was done well, but a few times I could tell when someone was on and off script. So you don't want to do that. And then finally, just as a warning, analogies or using terms that put the judge on equal footing is dangerous. Consider that you know your law, you know your facts definitely better than the judge. Maybe you don't know the law as well as the judge. The judge should know the law very well, but you probably know your area of the law really well. But when you use an analogy, you've almost given away your advantage, unless it's such an airtight analogy, because now you're just getting on at an intellectual level with your judge. And here you may lose. After all, there's a reason they're sitting perched above us all. All right. So I'm just letting you know how I do it. I don't like to give up my advantage that way. I'd rather get into a battle of my facts that I should know better than the judge and the law that I've researched the hell out of, so that if I don't know it better, I'm at least pretty darn close. But I thought it was really great for where you are in your careers. And as the director of our mooting program, when I'm looking for newcomers, I hope to see you all in the fall trying out for our teams. I wish I could force you to.
They'll be doing my moot, Professor Damesis. They'll be doing my moot.
Well, thanks very much. Maybe I'll offer a couple of comments, since Professor Damesis is just a public service announcement for the University of Ottawa Faculty of Law. I won't talk about that, but maybe just my impression. Really, as somebody, I haven't been in the courtroom as an advocate for now 15 years, but I certainly do go to the Supreme Court, whether in person or in, now virtually, and watch cases. And I guess I'm still surprised how often counsel doesn't realize that they're not the most important people in the courtroom, that it's the judges who are deciding the case. Your counsel, you have a brief, you have clients that you are trying to represent and come to the best possible outcome for your clients. And you certainly at the appellate level, you are there to help the judges deal with what is troubling them about your case and help them resolve those issues in order to arrive at a decision that is hopefully in your favor. And I think it may seem obvious, but all too often, counsel doesn't really listen to the judges or proceeds with their arguments. And none of you did that. You stopped immediately, or as soon as you could finish your sentence. You listened to the judge. You tried your best to respond to the questions. You should take questions as an indication of interest in your case and as a way to figure out what is troubling the judge. There were a number of you that asked, have I answered your question? Does that satisfy you? A number of you said, subject to any more questions. So I think you really understood the nature of the appellate hearing before you. I was very impressed and really very impressed.
Wonderful. So if there are no more comments from our judges, I do invite everybody to come out to watch our award ceremony happening at 6:30. The link can be found on the Walker Health Law Moot website. And just a little final note for our judges, we are going to be announcing the winners tonight. So if you could please try to submit your score sheets as early as possible, hopefully by about 6:15, that'd be great. And if you are having trouble filling out maybe the feedback section, you're welcome to just send the scores to us first and then provide the feedback later. And with that, I pass along to Matt for some final remarks.
I just want to say goodbye to my good friend, Larry Colvin,
Wait, before you go,
who I haven't seen in years. Larry, send me your email. I'd like to correspond with you. It's at bernard@gluckstein.com.
Bernie, before you go, I wanted to congratulate all our appellants and respondents for doing such an amazing job. And I want you to take solace in the fact that you presented your arguments literally in front of the best, and you held your own. So I also, on top of that, want to thank our judges for giving up their Sunday evening to do this. When we wrote down our list of dream judges for the championship round, the names in this room are the names that we wrote down. So it's extremely surreal to see this come to life. And I thank each of our judges for being here and contributing to this experience. Judges, I hold a tremendous amount of respect for you. And so thank you for being here and supporting this and supporting our students. It means a lot. And that concludes the championship round, the Walker Moot. I invite everyone to join us at our awards ceremony at 6:30 p.m. See who took home the cup, see who won the awards. Thank you so much. I really appreciate it. Take care.
Thank you for allowing us to participate.
Thank you very much.
Thank you.
Thank you.